My Lord, if the court is ready, I'll resume where I was, which is Barrett and Duckett. It's Core Bundle of Authorities, Volume 10. I've showed you one of the two passages I want to highlight. The second one is at Bundle, page 218. Letters E to F, sentence beginning towards the end of the line, but I see no injustice in that. On her own evidence, she lacks the means to pursue this action further. As the company does have some money which might be used in litigating the claims, it is my opinion manifest that it is better. The decision whether or not to use the money should be taken by an independent liquidator rather than by Mrs. Barrett. The important point there is the fact there was a liquidation scenario. There was someone available to take the claim on behalf of the company, namely a liquidator.
Just put it another way, the wrongdoers are no longer in control.
Indeed, yes, that's the simple point, my lord. And also, Barrett and Duckett refers to the next case I was going to mention, Fargo, has actually happened earlier in time, but perhaps in the interest of time I can take you back a few pages to Bundle 214, so still within Barrett. Lord Justice Peter Gibson traced some of the case law going back to Ferguson and Walbridge, Privy Council decision at the bottom of 213. What I'm about to take you to is the bottom of 214, decision of Mr. Justice Walton applying the above reasoning in Fargo and Godfroy. Company went into liquidation, we see just above little g.
Excuse me.
Defendants applied to strike out, the application succeeded. I simply invite the court to read the quotation there from that case. Bottom of 214, then over the page down to 215D. So there we have three cases in which the claim wasn't allowed to proceed because there was no there was no wrongdoer control because of the presence of a liquidator. Contrast those with the next case I'm going to take you to, which I'm afraid we have to move to the composite bundle of authorities. It's volume 1. No, I apologise. It's volume 2, tab 46.
Volume 2.
Do apologise, my lords. Volume 2, tab 46. Case of Conor Nemeni and Rolls-Royce Industrial Power, decision of Mr. Justice Lawrence Collins. And if I can ask you to turn to Bundle, page 566. The paragraph 29 highlighted, referring to the cases we just looked at. It's the last 5 lines. Justice Lawrence Collins says, "This is not the occasion to express a final view. It seems to be that the notion that there must be no alternative remedy expressed in Barrett and Duckett is not an independent bar to derivative action, but simply an example of a case where there will be no relevant wrongdoer control. And consistent with that, just 3 tabs on in this volume, tab 49, Mumbury and Lapper. It's bundle page 629, paragraph 5 at the bottom. Alternative remedies, extremely important factor. It's not an absolute bar. The way put at the top of 630 is the central question in any case such as this is, would an independent board sanction pursuit of the proceedings?
So if that's the question in the instant case, the question is whether an independent trustee whose board of directors does not comprise the current board would think it appropriate to bring a claim against this point, ex-directors. How would he go about deciding that? I mean, he'd have to, depending on the substance, the subject matter, he'd have to evaluate whether it was worth the risk.
Yes.
Or differentially upon the interests of members of the scheme. He'd probably have to have some sort of Beddoes application, wouldn't he, to decide whether that was an appropriate thing to do?
Well, it depends how one goes about it. First of all, this would all be in the context of, we're looking at this through the alternative remedy perspective, but nonetheless, the questions your lordship posits.
Well, no, I'm just looking at it, the central question.
Yeah.
Would an independent board sanction pursuit of the proceedings?
Yeah.
And so what I'm saying is, right, well, we've got a trustee here. The claims that you or clients wish to pursue are claims by the trustee against ex-directors. How would the new independent trustee approach answering that question? He'd figure out whether it's worth powder and shot into, whether the directors are worth powder and shot, ex-directors, whether it's worth the disruption, whether economically it makes sense to do it, merits.
Yes.
And if the claim bore differentially on beneficiaries of the scheme, he'd have to do a better, well in fact he may do a Beddoes action in any event to make sure that it's appropriate to incur the cost of the litigation and charge the fund for it.
He may do other things. He may make a public.
He'd do those as well, wouldn't he?
Well, can I do the reverse? He may do a public trustee in Cooper application if he felt concerned and wanted to protect himself. But ultimately, it's an assessment of the value of the claim, having regard to those very factors your lordship said: powder and shot, the importance of the matter, the value of the fund. Is this vexatious? Is it trivial? But in terms of a claim based on the sections of the Companies Act, it's simply to say, was this for the purpose of the company? Were these actions taken, not taken, to promote the company's best interests?
Well, that's just part of the merits argument.
Yes.
I mean, I'm assuming, so what I'm saying is, if you're looking at how a trustee goes about answering that question in the trustee context, like our case, there'd be a number of questions which would have to be asked and answered.
Yes. Of course, there would have to be, the board, the independent board would have to sit down and these questions, decide whether they would sanction pursuit of the proceedings.
And at least two, okay.
Yes. So I accept that if there is no wrongdoer control, there clearly is no need for derivative action. So that simply isn't the case here, for the reasons I've explained. And accordingly in relation...
The converse is not true. I mean, it's a necessary but not sufficient, if I can put it that way. In other words, if there's no wrongdoer control, you can't have a derivative claim.
It's not, can I put this, it's not an absolute bar, but it's not an absolute let-through.
No.
No. That's what I want to say on the respondent's notice, the point of principle at this point. Now moving on to ground B, which is the question of the test of the exception to Foss and Harbottle. In summary, the claimants say that the judge erred at paragraph 43 in introducing into the test an aspect of financial benefit. We recognise, he said, it need not be exclusively financial. We say implicit in that it needs to be at least partially financial. We say that that isn't the test. The test following Estmanco, Aberaya and Harris is whether the directors here have furthered their own ends. That may, and in the vast majority of cases will be satisfied by an element of financial benefit, but particularly in a not-for-profit company limited by guarantee, that is not a necessary requirement. I want to structure my submissions here along the following lines. First of all, dealing briefly with the fact that this is a company limited by guarantee. Secondly, the expansion over time of the concept of equitable fraud and fraud on a power, how that dovetails into claims based particularly on section 171 of the Companies Act. Estmanco itself and how that's been interpreted in Aberaya and Harris, the concept of furthering one's own ends, and finally the impact and or availability of ratification. As I've said before, but it's important to press, this is the first multiple derivative claim concerning a not-for-profit company limited by guarantee, in which the only members are directors. As I say, the applicable test has evolved and must continue to evolve, and as I've said before, be wide enough to comprehend all the exceptions, yet be narrow enough to be practicable and workable. The exceptions to Foss and Harbottle are not simply analogous to absolute statutory gateways. They're designed to provide a pragmatic solution to address the harshness or injustice which would be created by a strict application of the first rule in Foss and Harbottle. Prior to Estmanco, the language typically used, not invariably, was fraud on a minority. That's a misnomer in two ways. First, one need not have fraud in the common law sense. And secondly, there can be more or less than a minority. In cases where there's a 50-50 interest, it's been generally recognised that that is sufficient to come within the scope. Minority speaks for itself. Here in this case, because of the structure of this company, my clients aren't in the minority.
They're not in the company at all.
That's the consequence of the point. We can go back to, we can put away composite bundle 2 for the moment and go back to the core bundle of authorities. And turn back to Estmanco core bundle tab 6. And it's page 93 of the bundle. It's the highlighted passage by the second punch hole, F to G, having considered Daniels and Daniels, which was a review of the authorities by Mr. Justice Templeman. The Vice Chancellor says, apart from the benefits themselves, the company's expense, the essence of the matter seems to be an abuse or misuse of power. So fraud in the wider equitable sense of that term is in the equitable concept of a fraud on a power. The classic formulation, the doctrine of fraud and power, can be found in the advice of Lord Parker in Thatcher and Paul, We have that in the authorities bundle, but it's cited by the judge at paragraph 133 of his judgment. And it's also cited by Lord Sumption in Eclairs, which I'm going to take this court to now. So we now need to go back, I'm afraid, to a different volume of the composite bundle, volume 3. Tab 63. And it's really paragraphs 14 and 15 of the judgment. It's bundle pages 866 and 867. Perhaps I can ask the court to read 14 and 15 to themselves. It's the fact that section 171B is a statutory reflection of fraud on the power test. We can see at the top of 867 between B and C has nothing to do with fraud. Again, between D and E, it's concerned with abuse of power.
This case has nothing to do with the current facts.
No, it's simply the principles of law. Now, I say certainly in the case of a company limited by guarantee, and having regard to the articles of association I've taken the court to this morning, that if those with control of a company, such a company limited by guarantee, seek to act other than in accordance with the purpose, they breach the purpose provision at section 172 of the Companies Act. Your Lordship says, so what?
Well, no, I disagree. I mean, it's just, I think, fairly trite, isn't it?
Yes.
Actually, I mean, the fact this is a company limited by guarantee. I mean, in this case, the directors are or the members. That's not always the case with a company limited by guarantee.
Sorry?
With
Yeah.
a company limited by guarantee, I mean, it's not always the case that it has the same structure as yours.
No, and if it didn't, if they were a completely independent members,
you just
be in a
go-
different situation.
Yeah.
Yes,
I mean,
but we're in the situation we're in, and I say that that's relevant in terms of the concept of the abuse of power, which the Vice Chancellor identified in S. Manco as being at the heart of the question of fraud on the minority. A breach of section 172 would constitute fraud for those purposes, would come within the exception to the rule in Foss and Harwood.
no, I'm not sure that's right. I mean, no, sorry, if that's what you are saying, I'm not sure you are right. I mean, a director may breach his duties under section 172 in a whole variety of ways. I think when they're talking about fraud on the power, it's talking about the decision not to bring the proceedings. I think the focus is on a different decision, isn't it? In other words, suppose the director commits a gross breach of the duty of skill and care, that of itself is not a fraud on a power. It's just a
Under 174.
Yes.
Yes.
I mean, I don't see the material distinction in this respect
No, well,
between
that,
any of the other breaches that are direct to my thing. I thought the whole point about the fraud on the power, as we saw from one of the other cases, is it's the decision not to sue or not to vindicate the company's rights, which is said to be the wrong, isn't it? It's not the nature of the thing which gives rise to the claim. It's that the powers that you're given as a director to cause the company to sue is being misused because you are a wrongdoer and you're in control and using your control mechanism to, as it were, use the power to cause the company not to bring the proceedings for a purpose for which it's not intended. So the focus is on the decision not to sue, which is why in the other case, boiled down to the real question is, would an independent board decide to sue or not?
well, certainly the decision not to sue would be a paradigm example of an abuse of power for other purposes, but I say it's not so limited. That a breach, the risk of repeating myself.
Are you saying that any director who breaches a duty to the company, for example, a duty of skill and care, or is committing an abuse of power in the relevant sense?
Section 174, that's probably not, or may not be, fiduciary duty, skill and power. It's different. It's section 172, it's the acting for the, section 172, promoting the success of the company. Section 171, acting for the proper purposes of the company. Something, some act or omission, which constitutes the failure to act for the proper purposes of the company, I say is axiomatically the sort of action which comes within the scope of the exception to Foss and Harbottle. And aligned with the recognition that the focus was of abuse of power was the recognition by the Vice-Chancellor Manco that benefits need not be financial. And I say that where the law is at the moment is that if those with control of a company breach their duty by pursuing their own ends, or potentially the interests of another who's not within the scope of the power, that will constitute equitable fraud, such as to come within the exception to Foss and Harbottle. Manco, we've looked briefly at the facts
Well, it's
already.
quite clear from Sir Robert McGaughey's judgment, seems to me, that he was talking about the relevant shareholder there, well, the relevant party there, the council, acting for its own benefit, in the sense that it sought to pass, or sought to force through that resolution, which meant that the litigation had to be abandoned. So it was all to do with not, as my lord says, with the non-pursuit of the litigation.
Yeah. But again, it wasn't what the case authority is for, is it doesn't have to be a financial benefit.
Yeah, sure.
And the way the case has been interpreted in Aberaya and Harris is whether it's a political benefit, but some other benefit other than monetary.
Yeah.
And the judge, Justice Leech, apparently accepted at least some of that in his judgment.
Well, I still think you're tilting in a windmill with respect, because I don't think the judge was saying anything different.
Well, but it's important to, what I say is the scope of the exception, because even if the court is with me in relation to ground B, or says that it doesn't apply, nonetheless it clearly did feed into the actual decisions the judge made later on in each of the individual claims, 1, 2, 3 and 4, as to what the test was. So if we can turn back to Aberaya, again this was in the core bundle, tab 14, bundle page 313. And paragraph 23,
Sorry, I missed what you were saying because I was making a great deal of noise. Paragraph,
23, my lady, so bundle
Thank you.
313.
Yep.
Paragraph 23, beginning, Est Manco is not a case of financial gain to the majority and financial loss to the company. And while the court considered that, just to flag up the point in Est Manco, that the Vice-Chancellor made the point that because it was a not-for-profit company, the test couldn't be its financial loss.
it does say, it was a case in which the majority exercised their control over of the company to advance their own interests.
Yes.
That's because they refused to sanction the continuance of the action.
Yeah.
And that covered
Yeah.
the tracks in relation to the attitude towards the sale of the flats. But he goes on at 23, doesn't he? And as a necessary result to injure the interests of the company and its members. So there is an element of injury there.
Whether financial or otherwise. Tab 16 is Harris and Microfusion. And as I said before, this is a case concerning an LLP. The individuals involved were members of the LLP. Nonetheless, it is describes a multi-derivative claim, albeit slightly misleadingly, my Lord Justice Snowden observed this morning. And if we start at 353, begins the judge's analysis of Est Manco, starting with the observation that Est Manco was a very unusual case. And the passage I particularly rely upon is page 355 of the bundle, paragraph 29. I think that it is clear that Est Manco was a case where the majority was seeking to use the alleged breach of duty to further its own ends, in that sense to gain a personal benefit, albeit political rather than financial, and therefore was allegedly using its majority voting power to commit a fraud on the minority. To that extent, it is on all fours with Daniels and Daniels. I say, that is furthering their own ends. I say that could extend to the ends or interests of others, different people other than those who are the object of the power. We've noted before, but it's worth repeating in this context, the fact that in that case the wrongdoers were the shareholders, I submit wouldn't have made a difference if on the factual variation I posited this morning, it had been the directors who resolved not to continue with the action. My submission, that wouldn't have made a difference to the outcome. The real interest of Miss Cope, the applicant, was ultimately, as the judge recognised, her interest as a flat owner or prospective homeowner, rather than as a non-voting shareholder. Nonetheless, that wasn't determinative of the matter. While the council, as shareholder, had an interest in stopping that under the new political ideology, the same wouldn't be true of the directors of the company. But I submit that if that had been the fact, since the case had appeared before the court, that the judge's decision would have been exactly the same. That would have been another example of, would have been classified still as an example where the directors had furthered their own ends, interests, agenda by determining for the proceedings not to continue. And saying the fact that financial benefit is not a requirement is supported by some of the other exceptions to the rule in Foss and Harbottle, namely the two which I touched on this morning. Edwards and Hallowell, that's a case where the Court of Appeal had permitted members of the defendant union to bring a claim based on an increase in union dues in the absence of a ballot, which required a 2/3 majority prescribed by the rules. Difficult to see there how there would be a benefit of the type construed in many of these cases. Ditto cases such as Taylor and NUM Derbyshire, which was a case where ultra vires action was restrained. Admittedly, they're different exceptions to Foss and Harbottle, but they reflect the general principle. And I say finally on this point, further support can be found in MacDonald and Horn, that not procedurally a derivative claim brought by the beneficiaries of the pension fund. The allegations included, and one can see this in Mr. Justice Leech's judgment, amongst other things, lack of conformity with the interim deeds, breaches of trust, and abuse of powers, including excessive sums paid in fees and expenses. So I say that the test was not, and is not, there has to be at least some aspect of financial benefit, whether that is exclusive or inexclusive. There doesn't. And the final limb of the argument on ground B.
But of course, MacDonald and Horner is about cost indemnity.
I beg your pardon?
But of course, MacDonald and Horner is about cost indemnity.
Yes, and that's why it's a caveat. It's not a derivatives claim. Different. And the final argument is the fact that I say this all ties in to the requirement that the acts be incapable of ratification. I say this has been a feature of the case and goes back to the concept of wrongdoer control and the autonomy of the company's decision-making process, albeit it hasn't always been recognised as such. Perhaps the best place to start with is in judgment in Aberaya, given that we're within the core bundle. Back to tab 14.
Can I just sort of, because we're digging so deep into the reeds, as it were, of corporate law here,
Yes.
Which is an area with which I'm more than happy to spend time looking at company law, but I'm just struggling to understand the context in the sense that, as I understand it, you're saying that this claim should be brought by analogy to the principles of company law, not that the company law cases we're looking at are directly applicable, because they're plainly not.
Well, I'm not sure that fairly characterises my submission, my lord. I'm saying this is a new factual twist, but I'm simply saying that the test laid out in Fort Gilkicker, for example, that it's a question of whether someone has sufficient interest, is broad enough to encompass this factual scenario.
Maybe my understanding is that the whole basis of your application, which the judge ruled upon, was to apply the principles of company law by analogy, not that they were applicable.
Sorry, I'm lost, my lord.
Your application was to apply the principles of company law by analogy, not because this is a company law derivative claim. You accept it isn't because you're not a member.
No.
So ratification is a topic we're about to look at.
Okay, I now understand your lordship's concern.
Right, okay.
Sorry.
So we're about to get into the reeds, I think, of
Yes.
How ratification has evolved through a pure company law viewpoint, because it is a pure company law concept which can have no application in this case.
Well, I'm supposed to disagree, but even if we're doing with the vertical multiple derivative claim cases, ratification may still have been a relevant factor in those cases.
Ratification in the company law context is a question of whether as I would understand it, it's whether the members of the company, or indeed some other organ of the company, can ratify the breach, or by the directors of which complaint is made, was sought to be made.
Yes.
In the current case, the members of the company are those who are said to be the wrongdoers.
Yeah.
So your point is, well, they're never going to.
Exactly.
Ratification just doesn't arise in the sense
No,
that.
that's my point. My
In a sense, you never even get to think about ratification because you identify that the wrongdoers are the only people who could, in your context, ratify. So why do we need to get really into the minutiae of it from a company law perspective? The more relevant question, surely, is whether the other beneficiaries of the trust, on whose behalf these proceedings that your clients are seeking to bring, would have a view as to whether these proceedings, using their monies, should go ahead. That's the underlying ratification question, which is a very different one than the one I think you're about to get into, isn't it?
That to a large degree depends upon the prism by which one views this claim, either as brought or how the court ultimately decides it should have been brought.
But if you look at the underlying rationale for the ratification point in a company law context, it's you shouldn't allow one particular member of the company to use the company's name to pursue a cause of action when a majority of the other members, for example, who are not involved in the wrongdoings, would say, oh, for goodness sake, that's a bad decision to make. We don't want our the company funds expended on this litigation. That's the underlying point.
Yes, that's the rationale.
That's the rationale. So I'm trying to translate that by analogy to our case. And the analogy is surely, do the other members of this pension scheme think this is a good use of the fund's money? Isn't it? Such that if you went out to ask them, they would say, for goodness sake, don't start spending the pension fund's money on this litigation, or yes, go ahead, we do want the money spent on this. That's the context, isn't it?
But that question has never been asked in the derivative, it's a point I made this morning, but bears repetition. That's a question that's never been asked in the derivative claim context, even the classic multiple derivative claim context. As long as you have one individual who comes within the scope.
With respect, I'm not sure that's right.
No, I'm not sure it's right.
In the corporate context, I'm afraid in the bad old days pre-2000, when I used to inhabit this field, well, actually I inhabited it post-2000, but before you had that framework, it was often the case that Prudential and Newman is the example that springs readily to my mind, where you used to have the application to pursue a derivative claim adjourned so that the
Yes, exactly.
court could canvass the views of
Mhm.
the remaining membership.
Yeah.
So actually the question has come up.
But say it no longer would apply here on the facts of this case because of the identity of directors and members and section 239 of the Companies Act.
Yes, but if
Yes.
you're applying your Companies Act by analogy, you can't ignore the reason that the ratification is thought to be relevant.
But part of the reason it was relevant was, putting it the other way around, part of the reason why there was some test of benefit was to have regard to that principle of ratification. So decisions which were incapable of being ratified, such as fraud, that was the answer.
But that comes back to, as I say, we're about to get into some very specific company law doctrines, which, to my mind, are beginning to obscure the point here, which is if you're about to go into ratification and what breaches were or weren't ratified, the real question is, shouldn't we be asking the other members of the pension scheme whether they want their money spent on this litigation? That's the ratification that would matter.
May I reflect on that aspect of it and try and short-circuit this to say, your Lordship is clearly aware on every level level of where I'm seeking to go with this, and certainly the background of the ratification cases. The simple point is that, and I'll do this as quickly as I can, ratification is recognised as important in a number of these cases for the reasons which we've just canvassed. Yes, that's part of the driver as to why there was some requirement of benefit. I say that certainly in a case of concerning a company of this nature, where ratification is impossible, it really has very little part to play, and that's another reason for the court adopting a broader general test, a lower threshold of what is the constituent benefit within the second limb of Foss and Harbottle. Perhaps one final point I can make on this is to refer in a moment to case the Hong Kong Court of Appeal in Wan Pengying 2021, which considers, albeit obiter, that the true test as respects claims involving breach of duty not amounting to actual fraud was the lawfulness and the majority voting to exonerate a director for breach.
Where do we find that?
We find that, my lady, in the composite bundle towards the very end. It will be in volume 7, I think it's the last tab in there. It's 2 judgments which are concerned. It's obiter, but it's quite interesting.
Tab 100.
Tab 100, my lady, yes.
And where were you reading from?
I'm about to take the court to bundle page 2211. This is judgment of Vice President Kwan, and it's paragraph 65, which is the highlighted one. And then that's the first part of it. The second part is moving on to page 2220. This is paragraph 85, discussing the personal benefit to wrongdoers requirement of microfusion, offering the observation that the true test is whether there has been or would likely be misuse of the majority's voting power to release the directors from their breach.
To release the directors from their breach. So
Yes.
does that not take us back to what my Lord Justice Snowden was saying before, that the fraud on the power is the refusal to sue rather than the actual breach itself? I'm just wondering.
Well, it could conceivably be, but I'm saying it's not limited to that.
Mm-hmm.
The court is, we'll move on. I suspect it might be appropriate for some short break for the transcribers, but maybe not yet.
We do that normally about 3:15.
I'm grateful. Now move on to ground C, the test of a prima facie case on the merits for relief. The claimant's appeal is framed on the basis that we say the judge erred in holding at 45 that a claimant only makes out a prima facie case, where the court is satisfied that there are issues on fact which it would be wrong to accept the company's evidence without cross-examination. I say my learned friends in their skeleton argument seek to downplay the significance of the test the judge applied. They say he didn't apply a general test. but simply one which worked on the circumstances of this case. I say in return that shows the flaws and the consequences of this approach. My submissions are in brief as follows. First of all, prima facie is a lower threshold than good arguable case. Good arguable case is held to be more than barely capable of serious argument, but not necessarily better than 50% prospects of success. I say how one assesses whether a case is prima facie will vary. Sometimes it can be made out in the pleadings alone, even if one has regard to the totality of the evidence. I say crucially, one doesn't focus on the defendant's evidence and whether it's likely to be accepted. I say that's the wrong place to start. The question is whether the claimant's allegations merit consideration at trial.
Well, even if the defendant's evidence demonstrates that the claimant's case is hopeless.
Well,
it can't be right, can it? The court must look, this is, we're dealing here with an equivalent, if you like, of,
yes.
of the second stage. The first stage, you apply on paper, judge decides that on paper. It's usually, not always, but usually, there's only material from the claimants. There isn't anything necessarily from the defendants. Yeah. If the claimants then decide that they want to renew the application at a hearing, then the defendants have the opportunity to be heard, and they usually will be heard at that stage, and they will put in evidence. By analogy, that's what happened in the present case. Yeah. The judge turned you down on paper, and you then renewed orally, and at that point, the company put in a lot of evidence. Must be the case, that in deciding whether or not you've got a prima facie case, the court has to look at the totality of the evidence, which is before it.
I mean, yeah, and just to add before you answer, but I mean, in truth, because we know you're not under the Companies Act process, you don't need permission to continue this claim in its current format. As such, I mean, I'll put to the side for the minute the point about the fact that your clients are beneficiaries and actually this is in reality a trust claim, a trust derivative claim, a beneficiary derivative claim. But putting aside the requirements for that type of claim, because you accept you're not actually within CPR 19.9.
14 now.
14 is it?
Yes.
The one that's the new, you know, the one that
yes.
has the sets out the company, effectively reflects the Companies Act.
Yes. Mm-hmm.
What is it that brought you to the court to seek an application for the judge to apply a test? I mean, normally what would simply happen is that the defendants would just say, you haven't got a cause of action, strike you out.
Because it is recognised that CPR 19.9 as was, now 19.14, applies by analogy, or the good, sorry.
You say that, but
yeah.
I don't think it's quote, I've seen no authority to suggest it applies quotes by analogy.
No, so let me rephrase it. It's been held by Sir David Richards in Boston Trust that it is good settled practice to follow that procedure.
That was in relation to a true double derivative claim, wasn't it? By a shareholder of parent company.
Well, then we are back to whether this claim comes within the scope of a multiple derivative claim, notwithstanding the difference between the vertical structure and the position here, or not. It's another reflection of that.
Then to pick up on Lloyd's point, in a sense, that you say you can bring it, and the court doesn't need to ask itself the sort of strikeout question or indeed any other question like that. You just say, well, it has to be some sort of not fanciful type claim.
Well, the way in which the matter has proceeded to date is that this is a multiple derivative claim, and whether we talk about the hearing in February or particularly the contested hearing in March or April, as it turned out to be after the adjournment last year, was a claim based on a multiple derivative claim. That was the way both sides presented. There were arguments as to whether it was engaged or not, but nonetheless, in terms of the structure, that was how it was done. And by, not consent, that's too formal a word, but the independent position of both parties were that the rules of CPR 19.9 were to be followed pursuant to the settled practice identified in Boston Trust.
You now mean 19.14.
14, yes, 19.9 as were in at the time, now 19.14. I'll use the current terminology to avoid confusion. So that was the position, and that's why it was seen that this was initially made by way of the application issued in September, October 2021, was an application for permission. So initially the application was issued, not served on the respondent, provided to them to bene esse. Decision by judge in December on paper, set aside the hearing in February, you know the chronology, but it's important. Only then was the application served on the respondent, who put in evidence, came in, we had a week respond, the following week was the hearing, done in quite a compressed period of time. All done within the framework, whether one says it by analogy or otherwise, of CPR 19.14 as is.
I think that was your client's words, actually. The analogy.
Yes.
So as far as you're
Yes.
concerned, there's an analogy with the company derivative claim, and we are expanding possibly the circumstances in which those multiple derivative claims arise. We're in new territory. So there's that analogy, and then further by analogy, it's said that 1914 applies,
Yes.
but also by analogy.
Yes. And say, going back to Sir David Richards observed in Boston, it made him beforehand, that it would be useful if the Rules Committee would consider whether 19.14, as now is, should apply directly to multiple derivative claims. That then begs the question, clearly, troubling the court considerably, as to whether this is a multiple derivative claim. If the court is of the view that it is, I would hope that it would follow that in the same way as the vertical multiple derivative claims 19.14 applies by analogy, so it would here by an extension of that. But that is the procedural basis on which the parties have proceeded. We applied for permission to bring the claim by analogy with the position. And that is the basis of the application made before Mr. Justice Leech last year, from which we appeal.
All right, well you,
Yes.
okay, well you put it in that way, which in effect is imposing on yourself a hurdle of showing a prima facie case on the merits.
So what's the answer to the point that I was putting to you, which is that
The court has to look at the totality of the evidence
Yes.
before it, including the defendant's evidence, and if the defendant's evidence shows that you haven't actually got a prima facie case on the merits, then the court rules the matter is not to proceed.
Well, I agree with both parts of those propositions. Clearly, the court should have regard to the totality of the evidence. But the crucial thing is how and to what regard. And I say that here, the judge, in asking the question as to whether there are issues of fact in which it would be wrong to accept the company's evidence without cross-examination, he effectively reversed the burden of proof. He proceeded, I suggest, on a false basis that what the trial process is concerned with is what appears in a witness's statement, when quite often it's what is not, and what comes out in cross-examination. When I come on to the substantive claims themselves, I'll seek to evidence how many of the allegations the claim made, whether in relation to claim 1, claim 2, claim 3 or claim 4, were not actually disputed by the defendants. They put in evidence which went to the issue generally, but I say they didn't engage with the allegations made. So in each case, a prima facie case was made out. Doubtless they'll be hotly contested at trial, but that is the process for trial. There will be, I'll answer your lady's question.
Sorry, but isn't that different? What you're saying is that you don't think that the judge applied the test properly, whereas I thought that ground C was that the test itself was wrong.
Yeah.
in the sense of look at the totality of the evidence, but then he's saying, and presumably one implies in what he's saying, and I'm just looking at your grounds of appeal only, but it's implied therefore that claimant says X, contrary evidence, let's just put it that way, from a defendant, and then on that basis he's saying I have to accept that evidence unless it seems to me that it would be wrong to do so without having put it to the test. Let's put it that way. And you're then saying, you started by saying actually he's turning the burden of proof upside down, but then you were basically saying he had misunderstood the evidence about whether actually there were issues at all, which is something different, I think, Mr. Grant.
It is, but that was predicated upon his turning the test upside down. What I say the test should be is, court looks at the evidence put forward by the claimants, looks at the evidence put forward by the defendant, and asks, are the allegations made ones effectively which should be scrutinised at trial? And of course, if they don't reach the threshold, if they're hopeless or whatever, let's come to the precise test in a moment. And that is shown manifestly so by the totality of the evidence, or even because they're ill-conceived on their own, and in a really bad case, the court may even say, I don't need to look at the defendant's evidence. This is a legally incoherent claim. It must proceed no further. But what should have been done is to look at the allegations made by the claimants in the draft amended particulars of claim, and then having regard to the evidence put in support of the claim and against, whether those claims are ones which should be tested at trial. What he did in my submission is significantly different by focusing on the defendant's evidence and assuming that that is correct unless proved otherwise. And the procedural context, as I said briefly, was worth repeating, was the claimant's evidence went in September, October. After the setting aside on the 28th of February, the company then had a couple of weeks to put in their evidence, and the claimants had a week to respond to that. Now, you might say that's just the nature of litigation, but nonetheless, it's an important one. The phrase prima facie has various shades of meaning, but at the heart of it, it means at first sight. Clearly, part of the process is to weed out clearly the process is to weed out unmeritorious claims and to ensure that money is being used wisely. And whether the case justifies going to trial. Some of these considerations are deployed in the discretionary aspect of the inquiry. So even if there is a good claim, it might be held to be being brought in bad faith or worth very little money, such as not turn out to go forward. But at the moment, we're concerned with the merits. The deployment of the phrase prima facie in this context originated in Prudential. And that's because the well-known procedural history of that case, where the matter took an interminable length of time, and it's heard that there shouldn't have been a dress trial, but you don't determine the right to bring the derivative action on the assumption that all the allegations of fraud and control are facts. So there's more of an inquiry than there would be on a preliminary issue where you simply assume those facts for the present purposes. I say that prima facie must have the same meaning for the second and third limit exception to Foss and Harbottle. In other words, a prima facie case on the merits and a prima facie case you come within the exception to Foss and Harbottle.
It's actually a prima facie case for giving permission, is the phrase that you're actually concerned with, isn't it?
It is, yes. But that really breaks down to the fourfold test set out by the judge. Prima facie case and merits and prima facie exception to the rule in Foss and Harbottle. Prima facie has now been incorporated into section 261, and that was seen to reflect the common law test beforehand. And the two cases of primary concern are Aberaya, which we've looked at a few times already, of course, and Buller. Both of those are in the core bundle. We will need to come back briefly to Wang, but if we can turn put that aside for the moment, go to the core bundle. Core bundle of authorities, tab 14, Aberaya and Sigmund. It's page 319 of the bundle. And what the judge says there, if the court has the reference, second line, a prima facie case is a higher test than a seriously arguable case, and I take it to mean a case that, in the absence of an answer by the defendant, would entitle the claimant to judgment. In considering whether the claimant has shown a prima facie case, the court will have regard to the totality of the evidence placed before it on the application. And the tension there is between subsequent paragraphs. In the absence of an answer by the defendant, the claimant would entitle the claimant to judgment, and then the totality of the evidence. That tension is explored in the case in the subsequent tab, Buller and Buller. I'll ask the court to turn to this. It's the first time we've looked at it. Bundle page 330, under the heading, is there a prima facie case? The two companies are entitled to the relief claimed against JAT, JAT. There's reference to Prudential. 21 sets out the paragraph in Aberaya. I've just taken the court to disagreement between counsel as to what it is. Justice Morgan provides some adverse comment on the elusiveness of the concept of prima facie case in paragraphs 23, 24, having regard to American cyanamide. 25, important wording. One thing to ask whether the claimant has shown a prima facie case in the absence of an answer from the defendant, and another thing to ask whether the claimant has still shown a prima facie case when one takes into account the suggested answer. If the facts relied upon by either the claimant or the defendant are not disputed, there may be little difficulty. But what if the claim and the suggested answer depend, as they often will, on disputed facts? What if the resolution of that dispute will in due course require the trial judge to reach conclusions as to the credibility of witnesses? I consider that the court has to recognise it cannot resolve disputes of fact at a hearing which does not involve any cross-examination of witnesses, and which take place in advance of any formal disclosure of documents. It would be unusual to find that the claimant can establish a prima facie case if one ignores the evidence relied upon by the defendant, yet the claimant would still fail at trial if the defendant's evidence were to be accepted. Such a case I consider still open to the court to hold that the claimant has made out a prima facie case, because it would be wrong to assume that the defendant's evidence will be accepted at the trial. It may simply not be possible to predict with any degree of confidence whether the defendant's evidence will be so accepted. So clearly wrong to assume that the defendant's evidence will succeed at trial. I say, attention, wrong to adopt the approach the judge did, to presume that the company's evidence is conclusive, unless, and there are issues on fact in which it would be wrong to accept their evidence.
I mean, I don't really understand how this has sort of come about, in the sense that in a normal corporate derivative claim, there's a two-stage process. The first bit is on paper, and the second bit isn't. The prima facie case only comes around at the first on paper stage, where by definition you should only have in front of you the company's case. Sorry, the claimant's case. The claimant's case.
Yes.
Which he wishes to bring on behalf of the company. And he says, I've got a prima facie case here. If you think it's just barking mad, you throw it out. And if there's something in it, then you go to a situation where you have a contested hearing with evidence potentially filed on both sides. But at that second stage, the test is not prima facie
No,
case.
it's not.
So I'm slightly puzzled by all this stuff about taking into account evidence from both sides if the test is a prima facie case, unless you've got yourself into a situation, which I suspect Aberaya was, because it was a double derivative claim, sort of applying it by analogy, that you're sort of in a situation where you're actually addressing other tests, i.e. the tests under section 262,
Yes, exactly.
in which case I'm not sure quite what prima facie case. What's the relevance of it? I mean, if you're at a 262 stage,
You've passed it.
you should,
Yes.
according to the statute, already have passed the prima
Exactly,
facie
yes.
hurdle.
Yeah.
So I'm not really sure why we're getting into these thickets.
Well.
I mean, the real question on a contested hearing where both sides are present and have put in evidence, I think is the one that we were going back to before. Essentially, would an independent board, or in this case, well, yes, okay, an independent board of the corporate trustee, acting in accordance with its duties and not disabled by the conflict, the fraud on the power, whatever, think that this was an appropriate case to pursue. That is in fact what the court is directed to do at the section 262 supplementary stage.
Yes.
So I'm really struggling to understand why we're getting bogged down into this prima facie case stuff.
Because I say that the approach the judge took contaminated his findings on the individual claims, 1, 2, 3 and 4, as to whether my clients had made out a prima facie case for permission. And if that is simply a reflection of the basis on which the parties have gone down and the court's view as to whether that was right or wrong or not, then it is a reflection of that. But that is why your lordship's quite correct in terms of how the statutory test should apply. So client earth, for example, the recent judgment of Justice Trower, that was a statutory claim. Client earth, minority shareholder in the company, decision on paper, renew it. We understand there will be a hearing at some point in relation to that. And then if they get through that, then you get on to stage 2, which should be about everything post question of prima facie, section 262 and following. Aberaya is a double derivative claim. Buller and Buller, I think, I can check this, I'll be correct if I'm wrong.
Buller and Buller was a double derivative claim. It doesn't seem to have been a permission on paper hearing. Seems to have proceeded straight to an inter-parties hearing. At which Mr. Justice Morgan thought that the prima facie case test should be applied. But,
Your lordship is doubtful of that. Yes.
well, I agree with my lord. I think it's I mean, the latest learning on this is Mr. Justice Trower in the Shell case.
Yes,
a couple of weeks ago.
Yes.
Which is a classic. I mean, that is a section 260 derivative claim. But it shows exactly where the judge analyses in great detail whether or not the evidence that was put by client earth before the court established a prima facie case. And he concluded that it didn't. But that was without any evidence, I think I'm right in saying, without any evidence from Shell at all.
Yes, that's my understanding of the matter too.
And if which I anticipate there will be, there's an application to renew the application for permission on at an oral hearing, then there will be no doubt evidence from both sides.
Simply for the court's information, that application was made shortly afterwards, as one well expected. And from reading Shell's media output, they've said that a hearing has been granted. Whether or not that's the correct phrase, but a hearing will be heard. When, I can't say.
No. I mean, I would, and I certainly not speak for Shell, but if it's just an oral renewal at the behest of the party who was denied on paper,
exactly.
I would, in a sense, be slightly surprised if the company, defendant, or the company seeking to say, because of course it's not the defendants usually, it's actually the company.
Well, exactly.
I mean, in fact, it can be both. I mean, if you actually see the directions.
Yes.
Broadly speaking, the company comes in and says, we're not disabled, we can form an independent view, blah, blah, blah. If it's just an oral renewal by the claimant, I'm not sure why the company would need to add anything to what had already served it well on paper. The stage at which the company would have to go to the expense and trouble of putting in evidence to demonstrate that although it's a prima facie case, there are reasons why an independent board wouldn't want to pursue it, only comes at the third stage in the
Yes.
planet Earth
We call it
type
1A,
scenario.
1B and 2 or whatever we
Yeah,
call it, yes.
exactly.
Yes, yeah, no,
Because the last thing you want to encourage in the corporate setting
Yes.
is people jumping the gun with cost and expense on the statutory structure, unless the judge is very happy that it's a legitimate truncation of the process. Because otherwise everybody puts a massive amount of money and effort into
indeed, yes.
truncating the process.
Yeah. But then, with all those comments in mind, making my submissions as brief as I can, I say that, as I've said before, prima facie case is, or might be a lower threshold than good arguable case. And if I can take you to authority for that, it is authority 82, it's also a decision with Justice Leech.
82.
82, which is the beginning of volume 6. Two paragraphs very briefly, so it's 18 and 19. Sorry, did I say, if I said 86? I'm wrong, 82, my
You
apologies.
said 82.
Did I say 82?
Yeah, so we're page 1627.
Yes, well, you're ahead of me, my lady, but
Culture servant severe.
yes. So beginning of 18 is the highlighted sections, not precisely the same as test of good arguable case, conjunction. Accepted in principle, it might be a lower one, no practical difference between the two tests. And 19 reading on, good arguable case, more than barely capable of serious argument, not necessarily one which the judge considers would have a better than 50% prospects of success.
Just while we're there, but it's
Yes.
it was the passage I was searching for earlier
Yes.
when I made the point about ratification, just at the top of the page while you're looking at it.
Yeah.
And that's what the Court of Appeal said in Prudential. You might actually canvass the views of the interested shareholders.
Yes.
Which used to give rise to lots of fun and games.
And something, again, for your lordship's information, something not dissimilar was contemplated in McDonald and Hall in the pensions case.
Well, I mean, at some point, you know, we have to face up to the fact that we put to you at the start
Yes.
that if this case were run as a beneficiary
Yes.
derivative claim, if I use that expression in the Roberts and Gill
Yes.
type, there would have, I think you accepted this, there would have to be a number of preliminary questions that would have been asked.
One
Yes,
was
no.
what was the interest of the beneficiaries?
Yeah.
Yeah.
Fine.
Same point.
Yeah.
Just on that prima facie case point,
Yes.
I noticed that Mr. Justice Leech cites again Mr. Justice Morgan.
Yes.
Although he doesn't refer on this occasion to the gloss.
Yeah.
I think this judgment was about 6 months later than his judgment of
Yes.
5
Judgment
months
under
later,
appeal,
the
yes.
present case. Should we have a break for 5 minutes?
Yes, we go for the time.
Right.
Submissions from Shell.
No evidence.
It does, there's no evidence of evidence for submission.
Yeah.
don't have one with me. Is that I've got seconds writing one film, so like if I that really is how fast time goes.
It's a striking case.
Yeah, and lots of nice analogies which don't match up. Yeah, you fight a good fight.
My lord, my learned friend Mr. Short has helpfully reminded me that in the Client Earth case, submissions were put in by Shell, but we remain with the understanding that no evidence as such.
Yes,
Used.
I do remember that day. Because
Yes.
because one of the things that stuck in my mind, I'm not sure where it came from, but there was some evidence, there was some
Yes.
material as to what the extent of the shareholding held was, and that was one of the points the judge made.
That was, it was 27.
Had 27 shares out of umpteen thousands and thousands
yes.
of shares, and
Yes.
nobody had put in any evidence as to what the other
Yes.
thousands of shareholders thought, which is essentially the same point as my lord was making about
Yeah.
prudential.
Yes. Yes. Well, when we come on to claim 4, which was the environmental
Now,
claim.
speaking for myself, I would need a lot of convincing, however this claim is presented, whether you're right or wrong as to the way in which you put it. I would need a lot of convincing that said that this claim should be allowed to proceed in circumstances where there is absolutely no material before the court to suggest that what your clients are seeking to do is something which is supported by the other members of the scheme, let alone the majority of the members of the scheme.
Well.
That's exactly what prudential contemplates. It's exactly what's required in the trust cases. And what you're trying to do is to bypass all that in this ingenious way. Anyway, there we are.
I wouldn't necessarily
Right,
subscribe
where are we
to the
going
characterisation as ingenious, but clearly it's a
It's
development.
intended to be a compliment.
Well, the
Where are we going
compliment is not due to me, my lord.
Where are we going next?
We're still on the points of prima facie. I'll try and conclude this as briefly as possible. What I want to do perhaps is take the court to Tulip Trading's, the recent Court of Appeal decision.
Yeah.
Yes, that was on a serious issue to be tried as serving out the jurisdiction. A different test, but nonetheless.
Well, I think one's got to be very careful going into jurisdiction cases, because that is a different, depending on which stage you're at, it's a different test. There's the better of the argument point.
Yes, well,
It's a different test.
the test there was serious issue to be tried.
Right, what time are we in?
We are in tab 84.
Right. Yep.
Sorry, I was taking out the wrong one.
Tulip Trading.
Tulip Trading. This is a crypto case. Mr. Justice Falk, first instance, declined to allow service out.
Yeah.
First reference, bundle page 1713. Test with a serious issue to be tried. That's really the context for what I rely upon later on at paragraphs 86 and 91.
Yeah, same as the summary, test of summary judgment.
Now,
Yeah.
that was a case where cutting through the factual background significantly, the claimant's crypto assets, or the keys to the crypto assets, have been stolen by wrongdoers. And it claimed that the software developers had a fiduciary duty to help him regain access to his property. Now that goes against quite a fundamental starting point of fiduciary duty, that it's normally concerned with prohibitory matters, they're not prescriptive, it's not absolute. But nonetheless, that was the context of what was a difficult claim. Paragraph 86, Lord Justice Burse, I think it was, giving the lead judgment, says that I recognise for Tulip's case to succeed would involve a significant development of the common law on fiduciary duties. I do not pretend that every step along the way is simple or easy.
Well, it's the point he makes in 91, isn't it?
Yes, that's where I'm coming to next.
In
Yes.
91 is that he's not saying there is there is definitely is a fiduciary duty, just that the question
Yes.
of whether there is or not should be tested by reference to the facts and found at trial, on the basis that they've got shown a sufficiently arguable case
Yes.
for trial.
And we know that one of the benefits of trial, and I'm reading from the Pensions Professional Negligence case, PSGS, which is in our skeleton, that one of the advantages of a trial is that the court is able to evaluate documents and their likely impact in a fuller context. It can reach a better informed view of the probabilities. This is not always a reason for refusing summary judgment, but it is often a reason for caution. I say making the necessary adjustments for the different tests, that is still apposite to the question here. Okay. Focusing on an assumption of accepting the company's evidence without cross-examination, as I said before, is the wrong place to start. The test should be whether the claimant has adduced sufficient evidence to satisfy the court there are reasonable grounds for believing that the case is well-founded. The judge's approach elides the distinction between a claim that is good in law and good in evidence. We accept there's an evidential burden on the claimants, but the burden is to outline a sufficiently arguable case. It's not to adequately answer or undermine the defendant's evidence. The judge's approach ignores the fact that in a case like this, the company controls nearly all the evidence. Ignores the possibility of expert evidence and further evidence coming out and witness evidence. And as we'll see, particularly in Claim 1, that there will be, if this matter ever got to trial, considerable detailed examination of what was said, what was meant, what was done, given the complexity of the issues at stake. That doesn't make my argument more difficult. Quite the contrary, it just shows the reality of a case of this nature and the fact that the test should not be whether the defendant's evidence is to be accepted without cross-examination or not. And when we come on to the individual claims in turn, we will see that some of the allegations, at least, are ones where really there is no dispute on the precise points. There'll be plenty of scope for argument as to what the consequence is which follows. Nonetheless, I say that the claimants have made out sufficient case on each of the four claims. My lords, that is the end of what had been my ambition to complete by 1 o'clock today. I'll obviously continue now for as long as the court is willing to sit, but I won't finish today. What I have mooted to my learned friend is trying to make as best progress as I can tomorrow, while still giving him sufficient time.
Well,
a
the
day.
position is this, so you both know, and how you cut your cloth is a matter for you. We will sit till 4:30 this evening. We will sit at 10 o'clock tomorrow morning. We will sit, I think we can sit till 4:30 tomorrow, we need to check that. It's supposed to 4:15. And then we will sit at 10 o'clock on Thursday, but we have to finish by 12:30,
Yes.
without fail. So
And-
how you divide the time up is a matter for you.
Exactly. Well, then, all I'll do is express my
So
gratitude.
that's
I'm
giving
sure
you
there's
an extra hour in the 2 days.
yes.
because normally we finish at 4:04. Right, okay.
So we can now put away, at least the time being, the authorities bundles. And we turn to claim 1.
We're in the call bundle now, Mr. Grant.
I'm sorry?
We're in the call bundle now.
The yes, not the authorities bundle. It's really the supplemental bundle 2, in particular. So this is
So
claim.
we've got supplemental bundle 2A and B, so which tab are we at?
We're not at any yet. I'm just
Oh,
simply.
okay.
I do
Oh, sorry.
apologise. Simply
Yeah.
outlining where we're going to be the majority of the time. So the claimant's case in relation, or claim 1 concerns the valuation. The claimant's case in summary is that in breach of sections 171 and 172, first, the directors persisted with the valuation as at 31st of March 2020. I say A, when it appears to be common ground, there was no statutory or other requirement to do so. And B, when there were very good reasons not to, when the market conditions were, and I quote from the company's own documentation, extraordinary. Secondly, we say the directors were in breach in selecting inappropriate actuarial assumptions. And thirdly, we say that the directors were in breach in inappropriately linking future benefit amendments to the funding of past service benefits, prioritising accrued service over the duty to all current and prospective members. We say that those allegations, make good, amount to a failure to exercise the powers for the primary purpose of the company and the scheme, and the correlative duty of maintaining a fair balance between scheme beneficiaries. And we also say that the exercise of the valuation powers was done so for an improper purpose, namely to stimulate benefit changes, which were the domain not of the company as trustee, but of another body. We have to overcome 3 findings the judge made, so grounds of appeal 1A, 1B and 1C. Those correspond with the grounds we're dealing with this morning. A is on reflective loss, B is the prima facie exception to Foss and Harbottle, C, prima facie case on the merits. The respondent's notice brings back into play the discretionary aspect of this, which I will deal with in reply. If I may, I'm going to start with ground 1C, which is the prima facie case on the merits. And the structure of my submissions is as follows. I'm going to deal with the constitutional and the legislative context. Secondly, the primary purpose of the company, we say is to be trustee of the scheme, we say was not to secure accrued benefits. We say the judge held in paragraph 55. Thirdly, I submit to the court that the directors were subject to a duty to maintain a fair balance between all classes of beneficiaries, including future beneficiaries. And fourthly, I'll suggest that the directors exercised powers for improper purpose in persisting with the actuarial valuation to drive benefit change. Next point is that the directors adopted the inappropriate actuarial assumptions, primarily in relation to the discount rate, and finally, we say the directors improperly clung to the valuation date. First point of those, the constitutional and legislative context. We have looked already at Articles 71, 74 and 2 of the Articles of Association. The points I wish to make are these. We can turn them up if that would be helpful. It's the supplemental bundle A, tab 25. Bundle page 121. The objects, we looked at this morning to remind ourselves what the primary purpose is: to undertake and discharge the office of trustee of any superannuation scheme.
Just so I'm clear of what you're doing here.
Yes.
You're there's no greater iteration that the only iteration of the duties that you say the directors owe to the company are those set out in the statute. There's no more detailed duties than that.
No, it's the statute against the context of these articles of association as to what the purpose of the company is.
Well, okay, so you're going to have to draw for me, as a company lawyer,
Yes.
the link between section 172, or at least more particularly paragraph 32 of your pleading, which sets out the duties of the directors that you rely upon, and the very specific instances which you have been referring to of what you say the directors were required to do, or to refrain from doing.
Did your lordship say paragraph 32 of my particulars?
I think it is, isn't it? Yeah, your draft amending particulars of claim, paragraph 32. You just say these are the duties of the company, and you just set out,
Yes.
in fact, frankly, by reference to the headings of on the statute,
Yes.
what those duties are. And I know you then say there are a lot of things that they did, and you say they breached them, but there's actually a connecting factor missing there.
I'll seek to make that good.
Yeah, because I for one would need to understand why, to pick up something I think you said, that the directors, in fulfilling their duties to the company, the directors had a duty to hold the balance fairly between different beneficiaries of the scheme. Now, if you didn't say that, I apologise, but I thought that's what you did say.
Yeah, it is.
I did.
And I understand why the company as a trustee of the scheme might, if you pleaded it out, have a duty of that sort, which may stem from the scheme rules or from some pension trust law. But at the moment I'm struggling to understand how you say the directors had that duty owed to the company. I would understand that the directors would owe a duty to the company not to cause the company to act in breach of trust, potentially. Unless there were certain mitigating factors, possibly. But I'm struggling to understand how I thought you sought to cut the corner. And if I misunderstood what you were saying to me, I'm sorry, but I thought you were trying to cut the corner by saying that the directors owed a duty to the company not to differentiate between groups of beneficiaries, for example. And you didn't complete that, and B, I want to understand conceptually how you say that's the case.
Certainly. Well, can I come on to that in due course?
Sorry,
I've sketched out no.
It was simply the way you said it, because
No.
I think somewhere along the line I was trying
Yes.
to follow you, and I think that's where I lost you.
Fine, okay, well, I'll start again. So the point one, I'm trying to provide the constitutional legislative context. Articles 71, 74 in particular. Article 2 is less important. And perhaps of the Articles of Association, setting down the primary purpose of the company as trustee. And say that the objects of the company in Article 71 are linked to the purposes of the scheme. And under section 172, promoting the success of the company, reading in the gloss of section 172.2 we looked at this morning, is promoting the success of the company for the benefit of scheme members, i.e. promoting purposes of the scheme. So that's a duty of the directors, owed under section 172, to promote the success of the company, viewed through the prism of those for whose purposes the company exists. We say the members of the scheme.
Okay, this is where this is where I'm beginning to.
Yes.
It sounds very good. It sort of sounds it sounds very smooth when you say it, and I'm just not sure I'm following you.
No, well, I'm not seeking to pull the wool over anyone's eyes, my lord. That is the.
Sorry, nobody's suggesting you
No,
are.
no, but I'm
We're just trying to understand
Yes.
the logic of your.
Yes.
Sorry, I mean, sorry, it was intended again as a compliment, not anything else. I understand why the purposes of this company, the objects of this company are to act as a corporate trustee. And I understand why, if a company director of a corporate trustee does something which causes the trustee to breach its trust to the beneficiaries of the trust, that it might be said he acts other than in accordance with his duties to the company. It's not a given. I think that's the problem. It's possible that a company might breach its strict duties as a trustee, but in fact, not necessarily, that might not necessarily result in a cause of action which you would have against the directors.
Yes.
But let's assume for the present purposes that a director of a corporate trustee company shouldn't prima facie cause his company to breach trust. I think that's about as far as I can go at the moment. Because once you start iterating various other ways in which it might be said that the company might breach its trust, you really are focusing on the trusteeship duties of the company as the foundation for this claim, which is where I think we started out this morning, which is where I struggle.
No, well,
You're trying to, I think, cut the corner.
well, I say, taking the example of causing the company trustee to commit breaches of trust, doing so cannot be for the purposes of the company or for the success of the company.
So let's say that it would be a breach of trust to differentiate between two groups of beneficiaries of the trust fund. Or might be. How does the director of the company resolve that question other than by the company trustee going to court, joining the parties and having the court resolve the question, or taking professional advice and acting on it?
Well, it may not need that. One of the things we're going to come on to see is that the company, through the directors, laboured what we say is under the misapprehension that there was a priority on securing benefits already accrued, as opposed to the interest of members who were still accruing benefits or potentially even future.
But we're there focusing in that
Yes.
very question, you're focusing on the duty on the trustee, aren't you?
Yes. But I say that on that premise, taking your lordship's question in stages, on that premise, we say that the company through the directors laboured under misapprehension as to what was right in prioritising one group over the other. That was a breach and a failure to promote the purposes of the company, which is to act as a trustee for the scheme and not to favour one group over another as a matter of disposition. This company is by its nature linked to the trust scheme. It's to be distinguished from the corporate for profit-making trust companies such as Lord Debenture Trust or whoever, who have shareholders and for whose purposes the company is run for the purposes of the shareholders, the members. Here, as we've seen previously, the members of the directors, the company is not run for their purposes. It's run for the purposes of the scheme, which exists to provide benefits for the members.
But that doesn't mean, and we come back to
Yes.
our discussion that we've had
Yeah.
at length, that doesn't mean that in effect that we draw a line through the company and that we allied entirely the company with the scheme. The company is the trustee and has a life of its own. And its life is to be the trustee of the scheme and to act properly as a trustee. Now, it may not act properly as a trustee, but it seems to me throughout your pleading, you're saying the company did these things and it can only do these things through its agents because it's a company. QED, the directors did it. QED, it's a breach of director's duty, which in effect creates a situation in which we collapse the different stages between a scheme, a company and its directors, and we get straight to a situation in which, in effect, you're saying the directors owe their duties directly to the scheme, because you've said that the directors have to act in a way which is always appropriate in relation to the scheme. And that's what is worrying me, Mr. Grant, that we ended up in a completely collapsed concertina.
I understand. And I say, in answer to that, what I've said before, which is that it goes back to the nature of the company, its purposes, and the fact that the duties owed by the directors are duties only owed to the company. So if the company can't enforce them, or someone can't enforce them in the company's past, no one else can. And it would be putting the opposite metaphor of the concertina, of putting a brick wall if one couldn't link potential breaches of trust or actions done in relation to the beneficiaries on the one hand, with actions done by directors on the other.
But the way you link it is you have a beneficiary derivative action.
Yeah.
The beneficiary says the directors of the trustee have breached their duties, causing the trust company to breach the trust to me. I am entitled, because there are special circumstances, to pursue the cause of action on behalf of the trustee. None of that requires you to go anywhere near company law, does it?
Well,
It does require you to go near and indeed engage with the process for a beneficiary derivative claim.
but that is different. That's still a claim on behalf of the company, or the qua trustee. That's different from a direct breach of trust claim, beneficiary against trust.
Yeah, I mean, it would be twofold. I mean, if the beneficiary of the trust says, you, the trust company, you are my trustee, I'm the only person I'm in direct relationship with, you discriminated against me in the way that you, the trustee, decided to apportion benefits under this scheme. I have my own personal right of action against you as a beneficiary always has against a trustee. In the normal case, you would expect the beneficiary to take that action, either on his own or as a representative of others who were similarly positioned and being disadvantaged like him. And that's where, with law debenture, it would stop. Because if and to the extent it was proven that there was a breach of trust by the trust company, law debenture would be good for the money. And they'd make good the loss, or there'd be a readjustment of the scheme. What's happened here is that because you've got a not-for-profit company, I suspect the concern is that somebody's hunting around for some people or entities that have
A deeper pocket.
either a pocket or can have, as it were, individual pressure put upon them. But the core of the complaint that your clients have is that they've suffered a breach of trust in a number of ways, isn't it?
In respect, it's not. And if we look at claim 2, there may be an overlap, but that's not the claim. Claim 2 is the claim saying as a consequence of the valuation matters, which we're about to come on to, there were then benefit amendments which took effect from 1st of April 2022 to reduce the threshold when defined benefits turn into defined contribution benefits, reducing the annual year-on increases for inflation, and reducing the accrual rate.
So that's claim 1, isn't it?
No, that's claim 2, is that as a consequence of the valuation, benefit changes were made on 1st of April 2022.
And they were discriminatory.
Yes, they're indirectly discriminatory, my lady has the point.
Right.
And claim 2 is something akin, I think, to what my lord is contemplating. We're saying, as a consequence of the breaches of duty in relation to the valuation, which led to the benefit change, the company, as trustee, has been exposed to the prospect of, whether employment tribunal claims, high court claims, it matters not which, by predominantly young female members, ethnic minority, who've been indirectly discriminated against by the benefit changes. Now, claim 2, being brought by the two claimants, is not that claim, it's the claim on behalf of the company as against the directors to say, because of your actions, you have exposed the company to loss.
But I think it is what I was putting.
Yes.
I mean, the company only is exposed to that type of claim in its capacity as trustee.
Yes,
Yes.
So,
That's true.
whether it's regarded as a formal breach of
Yeah.
trust claim or whether it's some other claim that a trustee is susceptible to because of the whatever, it's again it's a claim by a beneficiary against the trustee.
yes. But that's the one example of that, and that's be a claim. And that's a claim we say that the claimants could not bring directly on their own behalf because they're not within the cohort in question, young, female, ethnic minority, etc. But that's a consequence that's a loss which flows from the valuation claim, which is at
But
the
if they
heart of
couldn't
claim
bring the
one.
claim directly themselves, why should they be able to bring this claim?
That's
Because
worse.
they're-
It's worse, isn't it?
Well,
Makes it worse.
no, it's far from it. They're seeking to bring the claim on behalf of the company.
Because if you look at it, it's certainly going back to what we keep on saying, if
Yeah.
you look at it in terms of a beneficiary's claim,
Yes.
where there would have to be special circumstances. One of the matters the court would take into account is that if and when there were claims by members of the scheme for discrimination, then they could bring the claims against the trustee or against the fund.
Those,
Your clients have got no interest in that at all.
again, those claims 2, the underlying discrimination claims brought under statute by members against the company trustee. They can be brought to the employment tribunal.
Well, they
Brought in the High
they haven't
Court.
been, have they? This is all speculation.
Well,
Your clients say, well,
Yes.
there's a risk that there might be discrimination claims
Yes.
against the fund and against the trustee,
Yes.
which haven't yet been brought.
no, but that number of points that, my lord, it doesn't make it any less a potential. It doesn't mean they haven't been exposed to it. By analogy with Section 2 of the Limitation Act claims, it's still a loss. The exposure to loss,
Well, why are your clients interested in that?
because it's something which the company is interested. This is a consequence of what has happened.
Why is it any skin off their nose, to put it colloquially? Does it affect their benefits?
Well, we say it does in this sense. If it exposed the company to discrimination claims, that which do come,
Have their benefits been affected or not by this risk?
Yes, my
How?
clients have.
They've suffered actual loss.
Yes,
Ah.
because the everyone's accrual reduced on the 1st of April last year in relation to surfers from 1st of April to.
No, that's not the loss
No,
though,
sorry.
that's not the loss, and sorry to interrupt you, but
Yeah.
I just,
No.
I didn't mean to interrupt you, I'm sorry. But the loss, I thought that you were alleging, which is why I'm concerned to hold on to my
Yes.
thoughts, in relation to the discrimination claims, is you say the discrimination has been caused
Yeah.
by the various amendments to the benefits, which will cause or may cause discrimination claims to be brought. And the loss to the company, which you're seeking to have redress for, sorry, my English has got
Yes.
really mixed up, it is that the company is now potentially subject to those claims, which is a loss to, you say, to the company. And then in that context, Mr. Grant, do you say, and I don't know, that therefore that is also, to the extent, you say it doesn't matter, but if it did matter, that would be a loss to your individual clients, because it generally is a drag on the company which will lead perhaps in future to a further drag on the scheme, which might lead to a drag on their benefits. Is that a
Yes,
fair way of putting it?
that is, my lady, that's the point.
Okay.
I'm sorry if I misunderstood the question which preceded that, which caused my lady to intervene.
No,
But
I
that's
was
what
just
we're-
concerned that I hold on to what I understood.
Yes,
All right, well, let's see if we can stick to claim 1 for the moment.
certainly. So we can probably move back in the bundle from the Articles of Association to tab 12, which are the rules of the scheme. We've only put in very limited extracts. And it is helpful to work backwards for reasons which we'll hope become apparent. Bundle page 61, Rule 79, the amendment power, which was part of the pre-reading. So, on the face of it, unilateral power, or the power in the hand of the trustee company, but subject to the consent of the JNC 79.5. The JNC at 79.7 has the power to recommend amendments. And then that sets in train the processes in 79.7(1) to 5.
Mm-hmm.
79.71, you'll see that the company has the power of veto when the amendment would, amongst other things, prejudice unfairly in any one group, members or former members compared with any other groups. We'll need to come back to the rules in a moment, but if I can quickly take the court to tab 26.
Sorry, so as I understand it, the JNC is it's the JNC that's critical here.
Yes.
Right? So the JNC, if it recommends, then unless it appears to the trustee company, which presumably means what? In this context, it's a defined term. What does that mean then? What does trustee company mean there?
Let's see if we've got the definition.
No, they're not included.
No.
Well, other than knowing it's the trustee of the scheme, in fact,
Yes.
62.1. So is this right? The JNC recommends an amendment. The trustee company has no discretion but to implement it unless actuarial advice is received to the contrary. Broadly speaking. Is that right?
The trustee company is page 40, so I don't know which page it is, it's page 47 in the middle. Rule 62, 62.1, the trustee company is the trustee of the scheme.
So basically, it's the JNC that, I'm not sure why we're looking at an amendment provision at the moment, but it'll become clear to me, no doubt. But in terms of the amendment, the trustee company as such just has a negative right of dissent.
And we'll see in the documentation that a virtue has been made of this fact, that the JNC has the primary role in setting the level and shape for USS's future pensions provision. It's a point that appears elsewhere in the bundle.
Okay,
So tab 26 you said?
Yes. Page 129. This is a document from February 2020, Principles of Decision Making.
so what is this document?
It's an internal document produced by the company, Valuation Principles for Decision Making. So you'll see at the top is page 128. I said 129. Third bullet point under 1. The JNC approves future benefits. JNC is the primary role in setting the level and shape of USS's future pension provision benefit design.
Right.
So that simply makes good the point my lord was making.
Right.
This is not a constitutional document,
No.
presumably.
No, but there's as will hopefully become apparent, this is a point which the company relied upon through the process as to its limited role. Back to the rules, tabs 12, we go to rule 76, which is the actuarial valuation rule. And that specifies, consistently with Part 3 of the Pensions Act 04, there'll be an actuarial investigation by the scheme, of the scheme even, by the actuary intervals of not more than 3 years.
So this is,
The previous valuation in this case was done on the date of 31st March 2018, so one was not required as at 31st of March 2020. I'll do when we get into the detail of that.
sorry, I've missed the, it's the 76.1, is it?
76.1, yes.
Okay.
And so these are the rules of the scheme, actuarial investigation of the scheme.
And as a result of the actuarial evaluation, the actuary may make recommendations in relation to contributions to be paid, etc. And on 76.3, in the event of the actuarial investigation disclosing that an alteration or addition to the scheme is desirable, the trustee company has to consult with the JNC and, in accordance with Rule 79, take steps to make appropriate amendments.
Exactly, yes. As I say, and my lady will recall, this is consistent with Part 3 of the Pensions Act. No suggestion that anything being done either within here or in the events which followed was inconsistent with the statutory obligations.
So they did this. You accept that you accept that the procedure set out in the rules was followed.
Yeah.
There was
But also,
there was an actuarial investigation, a recommendation for an alteration to the scheme, consultation with the JNC, and then a change.
Indeed.
What is the
But it's-
JNC?
Joint
I know what
negotiating
its name
committee.
is. I know what the
Yes.
what the initials of the letters stand for. What is it in law?
This, as I recall, in fact, there are two ways. I can tell what I recall and then stand to be corrected, or we can just check exactly. It's a body set up as a consequence of matters which have happened in the past, with
Is
a
it
specific
corporate?
role.
It's not a separate corporate body. It's
No,
not
it's
a legal entity.
No.
Just a bunch of people.
11 people, 5 of
Yes.
whom are UUK appointees, 5 are
Exactly.
UCU appointees, and
Yes.
1 independent member.
Rule 64.
It's page 48.
So we know that the company, according to the scheme rules, the trust company, the trustee, binds itself to act in accordance with recommendations by a group of people.
Yeah, that's what the rules say.
So if they do, the beneficiaries can't complain.
Because to headline where we're going, what we're saying is in fact actually it was the trustee, it was the company who effectively drove the benefit change in events that happened from 2020, 2022, despite the absence of any requirement to carry out evaluation at that time.
Never mind whether they drove it or not. If the JNC agreed it, what's the problem?
We say it was the circumstances under which the JNC agreed it. That was the issue.
What, because it was during the pandemic?
No, my lord, it's not quite as simple as that. It's because the contribution rates which were effectively threatened were such as to compel the benefit changes, notwithstanding the extraordinary circumstances economically as at 31st March 2020, and notwithstanding the absence of any need to carry out
Is it
evaluation.
alleged that the directors misled the JNC in some way?
Well, it's part of the claim is that these actions, as I said at the beginning of my submission some 20 minutes
Is it
ago,
alleged that they misled them in some way, that there was a misrepresentation or dishonesty or anything of that kind?
no, there's an allegation of improper purpose, my lord.
But hang on, but the company, the trust company, is bound to do what the JNC recommends in an amendment situation, unless it's got actuarial advice to the
Yes.
to the contrary.
We say what, but the whole structure of this is that it is led by the JNC. What we say happened improperly is that it was the trustee company who drove matters.
Did the JNC recommend the amendment to the rules?
Yes.
So, yes.
Okay, so why is the trustee company in breach of trust?
As I said, and I shall repeat, it inappropriately assumed a role in determining benefit changes when that should have been a matter for the JNC. And it,
But if the JNC was happy with what it did and recommended it, and they acted on actuarial advice, so unless the company in that situation under Rule 79, whichever one it is, 7,
0.1, yes.
79.7 is it? Unless the company took actuarial advice at that point, and the actuarial advice was, well, JNC have got it all wrong, then the company was obliged to agree the recommendation of the JNC. Okay, all right. Well, I think we should try and move on, Mr. Grant.
Yes, certainly. So I'll do as quickly as I can. Part 3 of this context is the Pensions Act 04. For some of the background, one can see the judgment at paragraph 48 and following. We say again, taking this as quickly as we can, there's little conflict between, not saying there was no conflict, but little conflict between the rules as they stood and part 3 of the Pensions Act 04. Section 224, referred to paragraph 51 of the judgment, that stipulates triennial valuations. And if no actuarial valuation is undertaken each year, there shall be a brief actuarial report. We say there's a significant distinction between reports on the one hand and actuarial valuations on the other. In relation to reports, there is no revision of statement to the funding principles, no recovery plan, no schedule of contributions. It's a briefer document which doesn't drive change in the way that an actuarial valuation did. It's common ground between the parties that the trustee company has 15 months to provide an actual valuation report after the as-at date. And finally, section 227 of the Act specifies that trustees are prepare a schedule of contributions from time to time, which don't have to be agreed with the employer under section 229. Next element of the submissions, as I say, there is copious evidence that the directors thought that they had a primary duty to secure benefits already accrued. Some of these documents are in the pre-reading. What is significant, I say, is that the trustee company, the directors, never used the word duty in relation to future service. I'm going to take in court as quickly as I can through some of the documents. First one, this is all within supplemental bundle 2. We may have to navigate between parts A and B. We start with tab 19, A.
Yeah.
This is an email exchange between Andrew Kuby and Jane Hutton. I referred to Professor Hutton briefly this morning. What we have here is her email, March 2019, giving effectively hearsay evidence of what Bill Galvin said to have said. Context to that is given later on in the bundle. It's dealt with in the judgment. We know Professor Hutton was subsequently dismissed from office, and the judgment quite correctly says at paragraph 145, we cannot determine precisely what Mr. Galvin meant. I acknowledge that. I say this is context, and by comparison, the following statements, I say, are clear, or at least sufficiently clear, given the nature of this hearing. We start Back at tab 26, the valuation principles document.
Which was at,
Tab 26, my lady, page
I'm so sorry.
128.
thank you.
First bullet point. First and foremost, the trustees must ensure that the existing benefits to members can be paid. That the scheme is sufficiently well funded to secure the benefits due under the rules and to make these payments now and in the future.
Right.
Move on to tab 27, the methodology and risk appetite for the 2020 valuation. Pages 135 to 137. But page 135 even. By the first punch hole under 4 risk appetite. Our primary objective and statutory duty as trustee is to ensure that the benefits our members have already built up can be paid as and when they fall due. We move on to tab 33. Consultation of the 2020 valuation. Page 202. Between the two punch holes even, 4-line paragraph. We have been guided throughout this process by our primary legal duty to ensure that the scheme can meet its obligations to pay the benefits that members have already been promised. We have also sought to ensure that contributions and investment strategies are appropriate for securing new promises. Over the page 203 by the second punch hole, trustee, our legal obligations and fiduciary duties mean our primary objective is to protect the benefits our members have already built up. Finally, tab 35. This is a USS Institutions meeting, Thursday, 10th of December 2020. Page 282. The second punch hole, pre-penultimate paragraph. Nobody underestimates the scale of these issues to be resolved in this valuation. But our duty as trustees, it is indeed our primary legal duty. It means our first priority is the security of our members' benefits.
What do you say is wrong with that? Security of members' benefits. The purpose of a scheme is to provide the benefits which have been promised, and they're saying our first priority is the security of our members' benefits.
Because it's looking at those, it's the security, it's the priority of benefits which have already accrued.
Doesn't say that.
Other documents do.
Yeah, but that one doesn't.
No, but the ones before.
I've seen the other ones, but that does
Yes,
not say
no.
that.
Well, that is so be it. But the simple point is, and your lady may foresee where this is going, is we say that the judge wrongly relied upon paragraph your lady's judgment in MNRPF, which we say is absolutely clear and correct on it, and imported in here to provide a greater duty than actually is the legal position under law. And this informs the misunderstanding by the directors of the trustee company that there was a greater duty to pay benefits which had already accrued.
So it's all my
Rather-
fault, Mr. Grant.
So
So it's all my fault, Mr. Grant.
my lady, I hoped I had made clear that it entirely isn't your fault. And I'm going to take the court to it in a moment. So if we can look briefly, we need to come back to the supplemental bundle, but in the judgment itself, just to see how the judge understood the submissions put to him and his understanding of your ladyship's judgment. It's paragraphs 55 and 143 of Justice Leech's judgment. So for those working within core bundle, first of all, we see a bit of context. Paragraph 54 of the judgment under appeal. Justice Leech sets out paragraphs 282, 232 and 233 of my lady's judgment in MNRPF. And then 55, judge says the company relied on these paragraphs in support of the proposition that there was no paramount or standalone duty to act in the interests of all the beneficiaries of the scheme, particularly where groups of beneficiaries might have competing interests, and that the primary purpose of the company was at all times to secure the benefits due under the scheme. The claimants did not dissent from this proposition as a matter of law or principle, but they played much greater emphasis on the overall purposes of the scheme set out in its constitutional documents. I didn't fully accept that, but we'll come to that after we've looked at paragraph 141 within the judgment.
So which paragraph? 141?
141, my lord, yes. So 143. Again, returns my lady's judgment. So decision provides authority for the proposition. Primary purpose of a pension scheme is to meet the statutory funding objective and to secure the benefits already due under the scheme rules. In my judgments, the statements in paragraph 75 above, which summarise some of what I've just taken the court to, do not support a prima facie case that the directors were acting for improper purposes. They're no more than a reflection by the chair and the directors as a board of their statutory duties and the court's guidance. Now, there's a notable difference between this scheme and the scheme in MRPF. And this scheme is open to future accrual, open
That
to new
scheme was
members.
closed, it was a
That
closed
scheme-
scheme.
To close both to future accrual and to new members. It was a case all about security of benefits. It wasn't a case about priority of different classes of benefits because everyone was in one class, accrued benefits. It's all to do with securing them in terms of getting additional contributions from different employers. And the real contest was between the employers as to whether that was appropriate or not. My lady's judgment quite correctly focuses on the purposes of the scheme, providing benefits in accordance with the trustee rules, which must be the case. My submission, my lady's judgment was again focusing on that scheme before her and the conditions there, not a wider proposition. But nonetheless, one looks back to paragraph 140 of the judgment, Ms. Justice Leech. The judgment says there, it's 140, Core Bundle 227, the company did not dispute the fact that the directors treated active members and deferred members or pensioners differently, or that they took a very different approach to accrued and future benefits. Indeed, Mr. Short took me through the 2020 valuation, the other financial evidence, to show me both how the dual discount rate worked and that its function was to provide a more prudent investment policy for accrued benefits, even though the assets of the scheme were administered as a single fund. He submitted that the primary purpose of the scheme was to secure benefits to which members are already entitled under the scheme. Now, I say that the company's position, which is a reflection of the understanding of the directors, which form the basis of the judge's judgment in 55 and 143 and elsewhere, is incorrect. There is no greater duty in relation to accrued benefits, i.e. benefits which have earned to date. That point is crucial in understanding the reality, we say, of what happened from 2020 onwards. In fact, even there's a sense of it beforehand. There's no other source, whether in the statutory source, to show that there's subordination of future service benefits. That wasn't suggested by the company, wasn't found to be by the judge. The crucial point, as we say, is that there was a duty to treat members fairly. We say that is entirely consistent.
What does that mean?
Well, not necessarily equally, but you have to have due regard to all members and not have any disposition in favour of one class over the other.
That's the duty of the trustee.
Yes. We say that is entirely consistent with orthodox trusts law. My lady's judgment referred to Cowan and Scargill, which said, in the interest of time, I won't take the court to it, on it, is the best interest of the present and future beneficiaries, holding scales impartially. In a private trust context, that often involves a comparison between income and capital, life interest and remainder man. That's reflected in one of the new extracts in lieu we handed up today, a chapter on income and capital. When choosing investments, trustees are obliged, subject to the terms of the trust, to hold a balance between beneficiaries with different interests, particularly between those interested in income and those interested in capital. We say those duties of balancing the scales, of considering different classes fairly, extends to the valuation powers which were exercised in this case. There's no exclusion, and indeed we've already seen Rule 79.71, the trustee company's veto, if one class is being favoured or disadvantaged. As I said before, make clear, the duty to be treated fairly does not necessarily equate to a duty to be treated equally. It's an equality of consideration, not necessarily outcome. But we say that prioritising the interests of one and subordinating the interests of another classes is unfair. We say against that legal background, that contextual background, we say that the directors exercise the powers for improper purposes in persisting with an actuarial valuation to drive benefit change.
Can you unpack that into
Yes.
What they actually did?
I'm about to, my lord, yes.
In terms of what legally relevant steps they took.
Yes. Okay. That's what I'm going to. I'm conscious, I think my lord said 4:30, so another 5 minutes by the clock. For the purpose of evaluation
That's which
power.
clock you're looking at, that one there is about 3 minutes.
Well, I can't actually even see that one, I just realised. I'm looking by my.
No, I know, it's one
Yes.
of the weird things about this call.
No, well, in fact, there's one right in front of me which says 26.
Right, okay.
And as we know, as reinforced this morning, the judge's clock is always right.
Well,
So-
it's, I'm not sure. And we can either stop now or you can try and...
No, can I just do a few more minutes and there might be a convenient point to stop? I say the purpose of evaluation power is to value the scheme on a steady basis. The purpose is not to action change, for example, in benefit accrual, albeit the Rule 76.1, as we've seen, permits the actuary to make recommendations. Actually, what I'm about to do, in fact, is it going to do a little bit more and then I'll stop before I get into the thickets of this. We say what the directors sought to do here, and did do in fact, was to exercise the valuation powers for an improper purpose of forcing the JNC to reduce future benefits by way of amendment.
Sorry, so they exercise it for improper purposes to,
Force the JNC to reduce future benefits by way of amendment. We say it was not its role.
and when you say it forced the JNC,
Yeah.
you'll say it created a valuation at a difficult time, which led to a situation in which the actuary presumably suggested benefit changes. I'm not sure.
It led to a situation, we're going to get into the thickets of it, but just so that the court can understand.
But when you
the
say,
director's
just so
power.
that when you say forced the JNC,
Yeah.
you mean created intentionally created circumstances which placed the JNC in a position that they had to propose amendments.
Yes, there was a fait accompli whereby there had to be benefit change. And as the
That's a
judge,
convenient moment, Mr. Grant, will break now.
certainly, my lord,
Right,
I'm grateful to the court and all
10 o'clock.
staff for sitting.
thank you.
Alright,